Hi everyone, welcome back. And today we are going to discuss about traditional knowledge and IPR protection for it. So, what is traditional knowledge? Traditional knowledge refers to the knowledge, innovations, and practices of indigenous and local communities around the world. Now we have a famous Chinese medicine, then we have Ayurveda that is from India. Such knowledge is traditional knowledge. Now, developed from experience gained over the centuries and adapted to the local culture and environment, traditional knowledge is transmitted orally from generation to generation. It tends to be collectively owned and takes the form of stories, songs, folklore, proverbs, cultural values, beliefs, rituals, community laws, local language, and agriculture practices, including the development of plant species and animal breeds. Sometimes it is referred to as an oral traditional for it is practiced. Now sung, danced, painted, carved, chanted, and performed down to millennia. Traditional knowledge is mainly of a practical nature and particularly in such fields as agriculture, fisheries, health, horticulture, forestry, and environmental management in general. So if you look into this, we have seen in our day-to-day life we adapt many of the practices that is a traditional knowledge to another place. So each of it has a IPR protection. Now a particular community will have a particular form of agriculture or what of manufacturing of some of their indigenous products. So all these are traditional knowledge. Now, its role and value. Why is this traditional knowledge so important and why is it of significance and why does it need IPR protection? So, we have to understand its role as well as the value. There is today a growing appreciation of the value of traditional knowledge. This knowledge is valuable not only to those who depend on it in their daily lives but to the modern industry and agriculture as well. Many widely used products such as plant-based medicines, health products and cosmetics are derived from traditional knowledge. If you see, there are many research programs that are based on this traditional knowledge. There are many institutes that research on the authenticity and feasibility of mass production of this traditional knowledge, traditional medicines, etc. Other valuable products based on traditional knowledge include agriculture and non-wood forest products as well as handicraft. Now, traditional knowledge can make a significant contribution to the sustainable development. Most indigenous and local communities are situated in areas where the vast majority of the world's genetic resources are found. Many of them have cultivated and used biological diversity in a sustainable way for thousands of years. Some of their practices have been proven to enhance and promote diversity and at the local level and aid in maintaining healthy ecosystems. However, the contribution of indigenous and local communities to the conservation and sustainable use of biological diversity goes far beyond their role as natural resource managers. Their skills and techniques provide valuable information to the global community and a useful model for biodiversity policies. Furthermore, as on-site communities with extensive knowledge of local environment, indigenous and local communities are most directly involved with the conservation and sustainable use. Now, even we have to make use of a biological reserve in the most sustainable way, it is very important that we understand the local community and the local how these resources co-interact with the other elements in that environment. So that to understand that, the local community, the people who have been there for generations, they are the best people who can understand that, rather than it may take a person to years to study and understand, still the study be incomplete as compared to the knowledge of a person who has been there for generations and generations. So that is also traditional knowledge. Now, in the past few years, ample amount of discussion and debates on the subject of protecting traditional knowledge as intellectual property have been occurring at the World Trade Organization, that is WTO, Conference of Parties at the Convention on Biodiversity, etc. Now, a few national government in this discussion have embraced the view that traditional knowledge needs to be secured legitimately, and they have condemned the formal IPR framework in its available structure for not just neglecting to give satisfactory protection to traditional knowledge, additionally for legitimizing its misappropriation. In India, after the neem patent controversy, the need to protect the traditional knowledge of India has gained importance. So, neem patent controversy. What is that? In 1995, the European Patent Office, that is EPO, granted a patent on an antifungal product derived from neem to the US Department of Agriculture and multinational W.R. Grace and Company. The Indian government challenged the patent when it was granted, claiming that the process for which the patent had been granted had actually been in use in India for over 2000 years. In 2000, the EPO ruled in India's favor, but the US multinational mounted an appeal claiming that prior art about the product had never been published in a scientific journal. On 8 March, that is on 8 March 2005, the appeal was lost and the EPO revoked the neem patent rights, keeping the tree free of these patent restrictions. Now, so that is the most famous neem patent controversy, and it started in 1995 and the appeal finally came into a judgment decision on 8 March 2005. So it was a long battle. Now, while analyzing IP protection for traditional knowledge, it is important to determine as to under which category of IPR this traditional knowledge can be protected. Now, protecting traditional knowledge under Indian copyright law. Indian copyright law as such do not provide for the expression of folklore or protection or traditional knowledge of indigenous people. So copyright law discusses about an original work, an innovative work that is for the human desire or human need. So it doesn't speak about, as such, doesn't discuss about the protection of expression of a folklore that is not innovative, that is not new, then or protection of traditional knowledge of indigenous people, etc. However, an inference can be drawn from section 31A of the Indian Copyright Law, that is the Copyright Act. Which section? Section 31 capital A, which protects the unpublished Indian work. So the traditional knowledge can be brought under unpublished Indian work. The question that arises is, if granted IPR protection, whether copyright law would be sufficient for the protection of traditional knowledge. Now, the question here is whether the Copyright Act alone is sufficient to protect the traditional knowledge. Now, some of the major drawbacks in protecting traditional knowledge with copyright can be like authorship, the protection for limited time, then fixed form. Since traditional knowledge, we cannot identify an authorship, that is an issue. And the copyright protection is for a fixed time period, that is yet again an issue, and it has a fixed form. So, authorship. Under the Indian copyright law, protection is given to the author or owner of the work. Traditional knowledge is commonly owned knowledge and is generally developed and evolved through generations to generation. In such cases, tracing the author of the traditional knowledge is not only difficult but almost impossible. Now, the second point is that protection for limited time. That is, Indian copyright protection is time confined as it is granted for a particular term of 60 years. So earlier it was 50 years, then later by the amendment it became 60 years. The amendment was brought so that the Indian copyright law is in compliance with the international copyright law standards. That was based on the WTO agreement. So earlier it was 50 years and then by amendment it was made to 60 years. Traditional knowledge is imperative and it should have perpetual protection rather than limited protection. Now, the third drawback is that fixed form. To protect any work with copyright under the Indian copyright law, it is required that the work must be present in a tangible form. Fixed form of traditional knowledge is hard to find. In most of the cases, traditional knowledge is passed over generation in a community in form of stories. These stories are rarely available in fixed form. As per Indian copyright law, traditional knowledge fails to adhere the requirements that are precedent to copyright protection. Hence, the protection can easily be denied to traditional knowledge for not fulfilling the basic requirements for copyright protection. Now, protecting traditional knowledge, if it is done under patents, like the Neem conspiracy, here in which the US had taken a patent for the antifungal product from Neem. So, if copyright law is not sufficient, why not protect it under patent? So, here in India, patents are given to an individual for his invention. So, patents are given for invention. Copyright is given for innovative work that can be, that is innovative, that is artistic, literal, musical, literature, etc. And patents is for invention. Now, traditional knowledge is community-owned knowledge and not by an individual. Moreover, critics are of the view that traditional knowledge is naturally owned knowledge and not an invention. There is no invention in traditional knowledge. It has been passed on from generation to generation. Therefore, no patent protection can be granted to it. Patents are granted to inventions that is invented by a single act of invention, whereas the traditional knowledge is evolved and developed over generations. Thus, it is quite clear from the above contention that patent protection will not work for traditional knowledge. Now, how about including the protection under trade secret? So, we know that for an example, when we take a Coca-Cola company, there will be a trade secret formula for it, or a famous bakery or a famous other dessert shop. They will be having a trade secret recipe or trade secret formula behind their product, their key product, so that they don't have to disclose it. It is compulsory that they the product they have to include the ingredients, but there is an exemption that the trade secret doesn't need to be disclosed. So, what if traditional knowledge can be included and protected under trade secret? So, protecting traditional knowledge as trade secret is quite possible for the indigenous people, as it does not require any cost. All they need is a conscious effort on their part to keep their knowledge as secret. So, it should be kept as secret. Generally, traditional knowledge is intact with the community members only and therefore can be protected as trade secret. So far we can see that the traditional knowledge is best protected under trade secret as long as the community members keep it as a secret. And generally, it is always only the community members who would be knowing the traditional knowledge and not a stranger or a third person to the community. So, it can be well protected under trade secrets. So, as we see, India has quite rich and flourishing traditional knowledge, and this knowledge can be used in various ways in different sectors like pharmaceuticals, agriculture, then technology, then harvesting methods, storing methods, etc. But somehow Indian intellectual property laws fail to provide effective protection to it. So we can see that many of our Indian traditional knowledge has a patent in another country, or the things that we have been following for centuries. If we look into the patent or who is developing those technologies or those processes, that will be a different country. So, to check the misappropriation of this rich knowledge, some alternative measures like sui generis system and benefit sharing schemes can be taken up. The concept of benefit sharing must be encouraged when any research on Indian traditional knowledge is done so as to benefit the indigenous people as well. So that is with the traditional knowledge and how we can protect the traditional knowledge under IPR. We discussed about its scope under Copyright Act, its scope under the Patents Act, then including its protection under trade secrets. So thank you for listening. I hope this is helpful. If you like this, please click the like button, and if you are not subscribed yet, please subscribe to my channel. Thank you for your support. Have a nice day.